Hey everybody, Robert Wright here, private label law attorney, and today I want to talk about the differences between trademarks, copyrights, and patents. Now, when I was back getting my Master's of Law degree, I had a great intellectual property instructor. It was kind of intro to IP, if you will, and they gave some really sage advice. All too often when we think about intellectual property, we think about specific categories, right? We think about trademarks as being a specific category and copyrights being a specific category and patents being a specific category. And we just naturally kind of want to take whatever our thing is, right, and silo it off into one of those buckets, if you will. This professor said, don't do that. Treat intellectual property law as wrapping paper. And if you can trademark something, trademark it. And if you can also copyright some aspect of that something, do it. If you can patent an element of that something, do it. And the thought and the theory being that, if you've wrapped all those layers of protection around your intellectual property, if one of them kind of fails you, one of them doesn't work out the way that you wanted it to work, maybe it doesn't give you the type of protection that you were hoping for, you've got to fall back. And then if that one doesn't work, you've got another fallback. So it just makes sense to treat intellectual property like wrapping paper. We can only do that if we understand the difference between trademarks, copyrights, and patents. Okay, so let's start with trademarks. This is the primary type of intellectual property you're going to be dealing with private label. Okay, trademarks protect names, logos, and slogans. They are any one of those that you put on a product and you put out to market with the hopes that that name, that logo, that slogan is going to distinguish your product from everybody else's in the marketplace, right? So a lot of times people say, well, what's the difference between my trademark and my brand? There isn't any, right? Your trademark is your brand. And your brand can manifest itself in terms of a brand name, think Nike, or a logo, think the Nike swoosh, or a slogan, think just do it. So anything that you're putting on your products to distinguish them from other people in the marketplace, that is a trademark, all right? Now, copyrights are original works of authorship fixed in a tangible medium of expression. What in the world does that mean? In private label terms, that means your product photos, that means your sales copy, that means your package design. It could actually be that the product itself is copyrightable. So if you yourself have designed a pool float, it's not just your run-of-the-mill average pool float. It's not just a circular donut-shaped pool float. It is a pool float that's in the shape of a unicorn or a slice of pizza or a coffee mug or one of those goofy emojis, right? If you have done that, it's your original work, that's copyrightable. You should register that with the Copyright Office to make sure that you've secured rights in it, okay? Now, patents are kind of the other end of the private label law spectrum. There are two types. There are utility patents, and those protect the utility of an item. Now, for true private label purposes, unless you are creating, the next best mousetrap, you're not really going to be worried about utility patents, right? You're just not. True private label is finding something that's already selling, pulling it off a shelf from a supplier, putting your label on it, and getting it to market. So generally speaking, we're not registering a lot of utility patents. We're more concerned about infringing them, right? We want to understand, like, ooh, this product that I'm looking at, could it be patented? Okay, so that's one type, utility patents. Then there are design patents. These are patents that protect the kind of the functional design of an item, right? So if you have a that pool float, maybe you decide not to copyright it. Maybe it is a little bit functional. It's got a specific design, some different ridges in it. Maybe a different way that the handles are positioned on the float. That's when you're thinking about a design patent. So that's kind of the intellectual property spectrum as it relates to private label law. You've got trademarks protecting your name, logo, and slogan. Copyrights protecting original works of authorship, which mean your product photos, sales copy, package design, maybe the product itself. And you've got patents kind of over in the corner. We want to make sure that as we source products, we're not infringing anybody's patent. So we're not trying not to find and select patented items or ones that look like they have some sort of novel utility. And then design patents, we throw in the mix every once in a while. When copyright doesn't get us where we need to be, we can leverage design patents, and it'll give you a lot of protection on Amazon. Take that strategy, right? Don't think about intellectual property, just put it into silos. I want you to take your private label products and wrap it in as many layers of intellectual property as possible. The reason why, it's not to drum up business. The reason why is you absolutely have to do that to protect yourself on Amazon. Business is war, right? I say this all the time. business is war, right? And so you're gonna need tools in your toolbox to make sure that you're thwarting hijackers and pushing away copycats and making sure that people aren't stealing your sales. I'm also telling you to wrap up your intellectual property in as many layers of protection as possible, because when you look to exit, and we all do, whether you are being very purposeful about your exit or you just know that maybe you're being forced out, maybe you need life circumstances or you need to transition to something else, those private label sellers who have registered trademarks, who have registered copyrights, who have registered a patent, they have all their I's dotted, their T's crossed as it relates to private label and intellectual property. They typically get 3 times more for their business upon exit than those sellers that haven't done that. So don't just think about intellectual property protection as an expense to your business. It certainly is, but it's also an investment, and it's one that's going to come back at least threefold by the time you exit.